Welcome, everybody. My name is Jeff Fowler, president of the Apartment Owners Association. Today, we're going to be talking about the maximum allowable rent increases. All these numbers are brand new, and they go into effect August 1st, and they'll stay in effect for a full year. And before we get into that, AOA is one of the largest individually organized groups of apartment owners, been around for over 40 years. And our speaker today, man, he's been with us pretty much since the beginning and advising and helping us with forums and so much. And before we get into that, though, I think it's very, very important that everybody watching this understand what's going to be on the ballot in November. And we have this Justice for Renters measure that's on the ballot. It would repeal Costa-Hawkins. And this would really, really tank many property values. And so in New York, they passed this law back in 2019, and the properties that are under this law, the values of those properties dropped 34% since that passed. So in 5 years, they dropped 34%. And other properties that were not impacted by that appreciated 23%. So not only are you not getting your appreciation, you're losing massive value. And this Justice for Renters, there's a ton of money that's been given by the AIDS Foundation. They have like 13 million in it already. And when I look at what all the associations across the whole state have put together, it's a couple million. So we are really behind in fighting this thing, and we need to do a lot of advertising, and we need you to give to the AOA Political Action Center or give to another organization that's going to do advertising. We're going to do advertising. We have to get the word out, and even renters need to understand how this is going to really impact them. And it's all about the vacancy control. There's other things to it as well, but it would allow local municipalities to enact that. And so let's say you're being really nice to one renter and you're renting a two-bedroom to them for $1,100. And once they move out, you would not have the ability to bring your rent to market. And so just think the next person who would take that unit, man, that's a lottery ticket for them. But you can imagine how only the wealthiest would get that. And you can imagine how unmotivated you would be to make any improvements. And so tenant living conditions go down, and obviously you end up losing money. And so before we get there, really everyone needs to understand how detrimental this is for owners, but also just as much for renters, because there will be no investment. And really what they want to do, the end goal is really to socialize housing. We are all for an open market, not a closed market where only people in elected office get to pick which nonprofit organization they want to be able to do housing. We think it should be open so that everybody has an equal opportunity to invest into housing, and that people have an equal opportunity at receiving it. And when you limit and put restrictions on like this, it makes it incredibly hard, especially for people that are at lower income levels right now. And so anyway, go to the AOAUSA.com website. There is a political action page. Go to the main menu. You'll see at the bottom of, you'll see it there. You can also write a check either way, 100% reporting on it. And anyway, we've said it many times, we've written articles, but we want to communicate it over and over, just because I find that not everybody gets everything that we communicate. And also another one that's super important that people just haven't heard enough about is the fact that there are counties, including LA County, where they have removed the date of birth from the charge sheet, which makes it impossible for tenant screening companies to show you a criminal conviction on an instant criminal report. We have a new service. It's a live investigator service, and it not only does it search the criminal, it's searching the civil records. So it's looking at, just all kinds of things, like whether it's domestic violence, stalking, and even the financial crimes. I don't think you want a fraudster, moving into your apartment building and rummaging through the trash and finding key information on your other tenants. Incredibly unsafe for your tenants, and crazy that they would try to cover all of this up. So we've made a real shift there, and we're doing that. And if you're an AOA member, it's just part of it. There's so many other things that we could communicate, but time is short, so we're going to get into this. And we do have another live stream coming up at 12:30 about death in a union. But also, gosh, we have the trade show at the Long Beach Convention Center, the AOA $1 Million Trade Show and Landlording Conference. You won't want to miss it. There'll be over 20 speakers, including our speaker today. And there will be over 150 different booths. The last show we had, I think there were 190 different booths. So tons of vendors, and they are there because they believe they have something that can help you manage your property better, increase your return on investment. And so you will not want to miss that. Our speaker today is the just faithful writer of the AOA Legal Q&A in the Orange County edition and all the LA editions of our magazine. He has over 45 years of experience and 24 different attorneys on his staff. And he's had to ramp that up just because of how crazy everything has been. And he's founder and president of the law office of Dennis P. Block and Associates. So thank you, Dennis, for joining us today. Dennis Block.
And thank you, Jeff, for putting on these seminars. It's such a valuable asset that the landlord community desperately needs. We are being attacked, as you know, by our industry, by our politicians creating every single law, which obviously is just taking away and eroding our property rights. And it just doesn't stop. There's not any favorable laws that are being passed for landlords and to protect their property rights. It's just the opposite. I did want to start off just briefly. I want to share the screen here for just a moment. This happens to be my website, and if you do like what you hear today, the website is evict123.com. And I started every Saturday a Zoom meeting. It's also on YouTube Live. It's every Saturday at 3 p.m. in the afternoon. If you go to the website, and you can see right here where I'm pointing to, you can join our Zoom meeting. So if you like what you hear today, you can actually get your questions answered, or you can just sit back and watch the tales of woe by other income property owners as they give theirs. So that's something that you should think about if you do want to have some personal conversations with me and hear others. And again, that's at evict123.com, and that's every Saturday at 3 p.m. I do want to move over to what Jeff was talking about, which is this so-called justice for tenants. It should be called the nail in the coffin of the landlords. This will be the final nail that will affect our industry. Jeff, you were so right on in talking about how this will impact our industry to such an unbelievable level. As you noted in other jurisdictions, the loss of value to our property rights. This has already been on the ballot twice before. It was defeated twice before. We really need to give to the political pact for the Apartment Owners Association. We need to defeat this. And why? Well, Jeff went into some of the reasons. But number one, this would repeal Costa-Hawkins. This is the only favorable legislation that was passed back in 1995. And what did that do, ladies and gentlemen? Well, number one, it guaranteed that if you had a single family home, a townhouse, or a condo, that no municipality could pass any legislations to take away your rights to increase rent to market level. Right now, they are forbidden, Los Angeles, Santa Monica, or you name the jurisdiction, from passing any laws that would inhibit your right to raise the rent to market level. And when I say market level, the politicians are quick to use the terms rent gouging. There is no term rent gouging. Nothing sells or rents for more than what it's worth. If you have a $1 million house and you list it for sale for $2 million, you can, no problem, but no one's going to purchase that house. So the market and our free economy, which is the strength of our nation, determines what the things should go for, what services should go for what rent should go for. And this is the only industry in the entire United States where there's price controls. There is no other industry. Anybody can sell their car for whatever they wanted to. They can sell their house for whatever they wanted to. But again, they are limited by the marketplace. If this law passes, they're now going to put further intrusions onto what we can get for single family homes, townhouses, and condominiums, which is exempt from that legislation by local municipalities. It also would allow municipalities to set rent increases for properties built after December 31st, 1995. And last but not least, and this is the worst, municipalities would have the power, if this law passes, to do away with vacancy decontrol. Vacancy decontrol, in case you're not sure what the term means that if you have a vacant unit and maybe you had a tenant in there for 30 years and the rent was so low because of rent control, maybe it was $642, and that tenant left, maybe they left vertically, maybe they left horizontally, but some way, somehow that tenant left, and you now have a vacant unit, and you now finally are unshackled from under this rent control. Well, now, if this law passes, you'd be able to, the municipality could say, well, you're only entitled to a 10% increase. We have to stand together. We have to truly give. This will decimate our industry, which is already pretty much in the doghouse, but this will be the final nail in the coffin with regard to that. The other point that I wanted to make, which is coming up as of July 1st for the entire state of California, the entire state, where before we could charge up to 2 months security deposit, a 2-month rent security deposit. Now we're only limited to 1 month. So right now, for example, if you were renting an apartment or a house for $2,500, and you could charge, at least as of today, a total of $5,000 security and a total of $2,500 for the first month's rent. So that would be a total of $7,500. Well, the politicians in their ultimate wisdom, those who sit on our California state legislature, and that pesky guy who sits in the governor's mansion, we're now only limited to a 1-month security. The reason for doing that, in my example, would be that it's really difficult for tenants to come up with the $7,500. So we have to make it more affordable for tenants to get into units. What they don't understand is that that's leaving landlords with no protection. If the tenant fails to pay the rent or damages the property, by the time you finish an eviction case, by the time you finish that, it's going to be well over 1 month's rent. Even the damage to the unit, which can be thousands of dollars. So you're shedding away this protection. Also, the fact that a tenant has $7,500 is kind of a credit check. If a tenant doesn't have $7,500, and that means it's likely that if his car breaks down and he has to fix his car, that you're not going to get paid rent the next month. So it is somewhat of a credit check. So we need to explain to our politicians that what they're doing is they're making it more difficult for landlords for tenants to get into their units, because quite frankly now, ladies and gentlemen, you have to up your standards. If you can only get 1 month's rent as a security deposit, then you have to make sure that this tenant is not going to cause you problems, that they're not to be the type that damage properties, that they're not to be the type that are not going to pay their bills. So on that basis, we need to at least charge or at least request a 700 credit score Obviously, you want to do your credit checks with the Apartment Owners Association, but you have to raise your limit on this. And if there's any impediment, anything that you see from their past, then you want to reject this applicant because you have no protection. At least you had a slight amount of protection with 2 months rent, but now you're limited to only 1 month's rent. Now, there is an exception. The exception is that you're either a natural person or an LLC and you own no more than 2 properties with a total of 4 units, then you are allowed to have a 2-month security deposit. So that's 2 properties with a total of 4 units. But for example, if you had a triplex and somewhere else a duplex, that would be 5 units. You wouldn't be able to charge that. So my suggestion would be that put the triplex into an LLC and have the duplex in your own name, or have double different LLCs, because by doing that, then you're now limited under 4 units for that ownership. So that's a little bit of a way to get around this, is to have ownership in an LLC or in an individual's name and break it up. Now, of course, if you have a 5-unit building or more, you're dead. There's nothing you can do. But if you did have a 5-unit building and a duplex, right? Well, put the 5-unit building in an LLC, and then this way for your duplex, at least you'd be able to get a double month's rent. So that's the initial topics that we're talking about. Let's unshare my screen here and see what I look like again. I want to talk about another important topic before we get to the rent increases, and that deals with any kind of a change of ownership or change of management for your building. This has been a new tactic that tenants' attorneys are using to win their cases. And by doing that, landlords are losing thousands and thousands of dollars based on this little known rule. It deals with Civil Code Section 1962. If you rent the unit to this person, you're fine. You don't have to worry about Civil Code Section 1962. But if somewhere along the way you bought the property and there was always a rental agreement in place, or for example, maybe you switched your property from an individual's name to an LLC, or maybe you changed your company that normally pays the rent and you handed it over to a management company. In those situations, there's either been a change of ownership or there's been a change of management. At that moment in time, you need to send to all of your tenants a change of ownership notice. Now, on the AOA USA website, it's form number 156, and I urge you to do that. The reason for doing that is, if you didn't serve a change of ownership notice and you then start an eviction case for legitimately non-payment of rent, the guy didn't pay you for the last 4 months worth of rent, you will lose your case if it comes out that there was a change of ownership, there was a change of management. Even if you change the phone number where the tenant is supposed to call you, you got to do one of these notices again. If you don't, you will lose your case. And to make it even worse, if the guy owed you for May and June's rent, for example, and you served the change of ownership in June, under the law, that's Civil Code Section 1962, you're not entitled to the May's rent because the notice wasn't served until June. So let's go over what needs to go into that form. I'm going to share my screen again, and that's this one right here. So what needs to go into it again is, number one, you have to have the name, telephone number, and address of the person or entity where rents are to be made to. Also, and this is very important, you have to have the form of payments that you're going to be accepted. You just can't say, pay the rent over here to this person. You have to specifically state what the forms of payment you're willing to accept. So in my example here, if you can see my screen, it says, for example, personal checks, money orders, cashier's checks, direct deposits, or cash. You can augment that. You just can't have an electronic payment only. You can say a bank account, but if you're just going to have, let's say like Zelle, that can't be its exclusive rule of payment in the state of California. But you have to state the actual forms of payment that you do. If you don't, then your notice is defective and you can potentially lose your eviction case. You also have to have on this form the usual days and hours when persons will be available to receive payments of rent in person. So Monday through Friday, 9 to 5, that must be stated in the notice. And last but not least, and this usually is the irks most landlords, you have to identify the name and physical address, not a PO box, a physical address of the owner or the owner's agent who will be authorized to accept demand notices and legal process. That means that the tenant has to have an address, a physical address, a name of the person, the owner or his agent, where the landlord could walk over with a lawsuit and serve the tenant. Now, many landlords are reluctant to give a physical address. Like, I don't want these tenants coming over to my home. Well, that's nice, but you've got to comply with the law. So you can appoint your manager, or maybe you have a brother that you don't like, so you could give his address, but you have to give some sort of an address of an agent who's going to be able to accept demands and legal process. Failing to do that, then you're not in compliance. And again, if you start an eviction case, you will lose that case. I had a former associate of mine, a great person, did a tremendous jury trial. This is a couple of weeks ago. The jury came back 12-0 in her favor, representing a landlord who had failed to pay the rent. The other side made a judgment notwithstanding the verdict. That's a motion. And the judge begrudgingly had to give the verdict to the defendant on the basis that this Civil Code section 1962 was not complied with. So please, ladies and gentlemen, make sure that you use that form 156. If you have any doubt whether something has changed or not, it's not a big deal. Serve the notice today. This way you know you're in compliance. Grab that notice from the Apartment Owners Association. That's what you pay your membership fees for. And make sure you serve that notice if there's any doubt in your mind, because as long as you serve it from that point forward, you're protected. But if not, then you're going to have a problem. And this is being seized upon by so many tenants' attorneys out there. So it's a question we ask when we start an eviction case. And it's certainly something that you know now, you've got the knowledge now. Just comply with the law. Just send it as a matter of course. Send it out so you now are in compliance. We're going to stop sharing our screen right now. You're going to get the back to see my wonderful face. Let's talk about rent increases, because that's what the topic was all about. Before we talk about exactly what the rent increases are and what jurisdictions you're in, let's talk about how you increase the rent. How do you serve a rent increase notice? Well, again, those forms are on the AOA website. You fill them out and you're supposed to mail it to your tenant. You can hand it to the tenant. That would be one way. But otherwise, you're supposed to mail it to the tenant. Now, if you're going to increase the rent 10% or less, it is a 30-day notice. If you're going to increase the rent 10% or more, it's a 90-day notice. But here's the trick. And trust me, this has come up in cases that I've been involved with. And that is, if you mail the notice, you've got to allow an additional 5 days for mailing. If you mail the notice, additional 5 days. So if you're going to serve a 90-day notice, it better be 95 days. So whatever that is, you got to make sure that you serve it. Let's pretend by the 24th of, let's take June. So you got your 5 days in, and then it would be the 90 days would work out to be July, August, and September, which means that October 1st would be the day that the rent increase started. If you were doing a 30-day notice to make it effective, you've got to serve that notice by June 25th. Put it in the mail June 25th, unless you can hand it, then you don't need the mailing rule. And then that notice would become effective July 1st. So if you're going to be doing these rent increases, which we're going to be talking about in a moment, then you make sure that you are in compliance by serving a proper rent increase notice. Look, God knows that when a landlord brings a lawsuit, 99% of the time, he's bringing it for just cause reasons, that he has done what he was supposed to do and the tenant was not doing, was in violation of his rental agreement. So how do the tenants win these cases from time to time? It's very simple. They win them on procedural requirements. There are so many procedural requirements. It is so easy for a landlord to lose their case. In the LA area, there's a plethora of reasons by different municipalities that they have. So you really need to check with an attorney because these reasons are crazy, just like this with regard to this mailing rule. You mailed it on the 27th of June to take effect in August 1st. The tenant doesn't pay the rent at all. You bring forth your eviction case. You've lost your case. You didn't allow for the 5-day mailing rule. Okay, let's talk about statewide rent control and what rent increases are available that you can use in statewide rent control. If we talk about statewide rent control, we have to talk, well, is my property subject to statewide rent control? So let's figure out whether your property is subject to statewide rent control or not. So first of all, if your property is subject to a local municipality or a local county ordinance, you are not subject to statewide rent control. So for example, if my property is subject to the rent stabilization ordinance for the city of Los Angeles, it has nothing to do with state rent control. If my property is in an unincorporated area of LA County and is therefore subject to their statute, then you are not subject to statewide rent control. But if there is no local jurisdiction and you have residential property, I don't care what city you're in, you're going to be subject to statewide rent control, hence the name statewide rent control, which is also AB 1482. Now, there are some exceptions for your residential units. If your property is a single family home, a condominium, or a townhouse, or was built within the last 15 years, you are exempt from statewide rent control. And if you're exempt from statewide rent control, then you can raise the rent to any level that you want. But of course, we know any level that you want means market rent, because you can't take $1,000 apartment and try to get 5,000. You can do it, but you're not going to be able to get anybody who's going to be an applicant for that unit. So again, if it's a condominium, and this is based on the Costa-Hawkins law, which we're going to defeat this Renters for Justice Act, you want to make sure that you can raise the rent unless you're exempt. The exemption, again, are single-family homes, condos, townhouses, and properties built within the last 15 years. However, they put a little poison pill in that, and that is that you have to have language in your rental agreement that this property is exempt from statewide rent control. You have to have that language. I know on the AOA rental agreement, which I helped author and which I certainly recommend, that they do have that box to check that this property is exempt from statewide rent control. So let's pretend you have a single family home. I'm just going to pick a city where my law practice is in Burbank. That would not be subject to any rent control statute, but you do have to check that box. Now, little known fact is if you do have a single family home, a townhouse, or a condominium, and you didn't check that box, our position here at our firm is that because of Costa-Hawkins, you're still not subject to any rent limitations, but you would be subject to statewide rent control that you would need good cause to evict, okay? So, but what if, for example, your property is an 8-unit building in Burbank? So I know now, and it was more than 15 years ago, so I am subject to statewide rent control. So what rent increases can I have? Well, if that's the case, we're going to go back and we're going to share our screen again. And I got this beautiful chart from this great organization. And the organization you might know is AOA. So I go to their chart and to their website to figure out what the rent increase notices are. So currently for August 1st, if your property is subject to statewide rent control, as of August 1st, currently it's 3.8 is the CPI. That's right over here. This is for LA and Orange County. And then you add the 5%. So that's why currently today it's 8.8%. But since we're already in June and this takes effect as of August 1st, so for statewide rent control as of August 1st, you're entitled to 8.9% for LA County because the CPI is 3.9%. So if I had a property, let's say an 8-unit building in Burbank, so now I know I'm subject to statewide rent control, I would do my notice right now for a Burbank and I would raise the rent 8.9% to take effect as of August 1st. Now for Riverside County, as of August 1st, it's 4.3, which means therefore that's a 9.3%. San Diego, the CPI is 3.6%. So as of August 1st, and by the way, if you haven't raised the rent in 1 year, if you haven't, then as soon as this webinar is over, get out that notice from the Apartment Owners Association and send it out right now. You must keep your rents at market level or as close to it as you can. We all know that rent control is a cancer, soon to be coming to your area. So we want to make sure that our rents are at maximum market level. So if you have the right to serve a rent increase notice, serve it. Do not care that this is a nice tenant. You've been so nice and like them. Forget that. If you want to be charitable, as I always say, be charitable to your children, close family members, and the City of Hope. That's it. Well, you might want to change the last one for something different. But other than that, if you're in the business, then be in the business. Make sure your rents are at market level. If you don't want to do that, then sell your building and definitely give it to the Apartment Owners Association. They have the greatest realtors for selling your income properties. But otherwise, please treat it like a business. I'm telling you that rent control is going to spread everywhere. If your rents are at market level, they can't hurt you. But if your rents are below that $652 ocean view apartment in Redondo Beach, and they're only going to give you, quote, an 8.9%, you're not going to be happy with that. So you need to make sure that whenever you can legally raise the rent, like you haven't raised it in the last year, and as soon as we're finished here, don't go for your lunch, okay? Go straight to the website of the AOAUSA.com, grab their rent increase notice and serve it. Let's move on. I do have here, which is going to be talked about by my brother, attorney up in Northern California, but it's 3.8% for Alameda, Marin, Contra Costa, and San Francisco. San Mateo County is 3.8, so the total is 8.8. If you're not in a metro area, then for the state of California, it's going to be a total of 3.8%. So the total will be an 8.8% if you're in a non-metro area for the state of California. So again, if you can raise the rent, raise the rent, okay? Let's move on. So let me unshare the screen here so you get to see what I look like again. Thank you very much. In the city of Los Angeles, where most of my clients are, come July 1st, so what is that? That's coming up in about 17 days. The city council has allowed a 4% rent increase. So if you haven't raised the rent in 1 year, right now, today, because you want to give, if you're going to mail it, you got to give the 25-day mailing rule, which means your last day to mail it is the 25th of June. Don't even get close to it. Mail it before then, that you can raise your rents 4%. Now, if you raised your rents back in February, when the city allowed us to do that, then you can't raise it for 1 more year until February of 2025, okay? So make sure that you do send out your rent increase notices now to take effect for the city of Los Angeles or wherever you are. Send them out now, assuming you can legally raise the rent. Right now, actually, I'm misspeaking because right now for the city of Los Angeles, you can do it as of July 1st, which means this really can't take effect until August 1st of 2024. Now, if you happen to be unfortunate to own residential property in the unincorporated areas of LA County, and your property is not a single-family home, townhouse, condominium, then you're entitled right now to a 4% rent increase that will be through December 31st of 2024. So you could serve the notice right now if you haven't done it within the last year and raise your rents for that area to additional 4%. Serve it now to take effect as of August 1st, 2024. So that's basically the sum total of all my knowledge dealing with rent increases. Again, if you're not sure, you can check with the AOA and call their hotline, or you can call my hotline. I also have a ask question instant answers on my website at evict123.com. It's powered by artificial intelligence. It's also powered by a guy by the name of Dennis Block, who keeps feeding the robot additional information. So you might want to check that out on the top of my website for a quick answer. You should get an accurate answer, though we do revise answers if you leave your email address. And now, Mr. Jeff Fowler, I'm going to turn it back to you because I'm going to guess that there's a few questions, and I'm see if I can get stumped today, but I'm happy to answer them.
Awesome. Awesome. Thank you so much. And if you tuned in a little bit late, again, Dennis will be speaking at the AOA $1 Million Trade Show on August 22nd. Normally we do it in October. This year it's in August. So August 22nd, mark your calendar. And before we spin, we're going to have a little fun today. And we haven't done this in a while, but we're going to spin the prize wheel. And normally you have the prize wheel at the trade show, but we're going to do the prize wheel here and now. Let me get this thing going. Or let's see. There we go. I'll see if I can do this. And I'm hoping that it's shared. All right, so I'm going to click. We had over 1,000 people register today for this event. I'm going to click on this. We're going to spin the wheel, and the winner is going to get one of the prizes that we do have on that will be on the prize wheel at the trade show. So let's see, who will it be? Okay, info. They didn't put their name in, so yeah, we're gonna close that one and we're gonna spin it again. Yeah, if you don't put your name in, you don't get the prize, do you? Let's see one more time here. Okay, Sharon Johnson. Sharon Johnson. So what you can do is you can email us at membership@aoausa.com. And let me exit this. Or no, let's see. Close this thing. Stop share. There it is. All right. So Sharon, you can just email us at membership@aoausa.com. We'll get your address and we're going to send you this mug right here. So this is one of the prizes that will be on the AOA prize wheel. The prize wheels for members that come. When you come, it's free for everybody. You do get a free 6-month membership if you come. And if you've never ever been a member before, you'll get a free 6-month membership and a chance there on the prize wheel. So definitely come. Again, there's going to be over 20 different speakers and at least 150 different vendors, all that cater to people who own rental property. And yeah, we have a lot of questions. If you're watching from aoausa.com, there's a blue help button on the bottom right side of the screen. You can type your question in there and then they'll funnel that over to me. And then we'll get it to Dennis here. And of course, if you're on Facebook or YouTube, you know what to do. Definitely subscribe. Sometimes we release things that are not live streams. And if you subscribe, then you'll get notified of that. All right. So let me pull these questions over here. And Manohar on YouTube. How do we calculate 5% plus inflation last 3 months or every quarter? He's asking.
Well, that's done by the Urban Housing Development, HUD. And that came out, for example, in the LA area, it came out to 3.9% effective April. That's when they do it. And then you're entitled to the rent increase as of August. So whatever it was as of April, that's determined by our government and depending on what area or county that you're in.
Mhm.
And add that to the 5%, and that's the rent increase.
Great. And then Joe Hamilton, he's asking if you cover Riverside and San Bernardino counties.
We do cover Riverside and San Bernardino. We do not cover San Diego County anymore.
Okay. Yoshi on YouTube, to renovate an apartment unit that is currently occupied, can we ask the tenant to leave the property for some time? And how much would be allowable? And have them return to their renovated apartment with the rent increase?
Okay, well, first of all, we don't know what jurisdiction you're in. That's a problem. So if you're going to write a question, please tell me what jurisdiction. For example, if you're in the Los Angeles area and you're under the rent stabilization ordinance, you can't ask a tenant to move out and pay more rent upon when they're moving in. If the work truly needs to be done, if you're under LA rent control, then you have to get what they call a tenant habitability plan, where you're going to ask that tenant to vacate temporarily. You got to pay their relocation. You do the work that needs to be done. They come back at the same price. But let's pretend that you're in a jurisdiction that is subject to statewide rent control. Then you can do a renovation, eviction. You can, or if you're subject, for example, to the just cause ordinance for the city of Los Angeles or statewide rent control, you can serve on that tenant a notice to vacate, generally 60, that you're going to do substantial renovation. Substantial renovation is defined as work that will render the premises uninhabitable for at least 30 days. It does require that you obtain building permits like an electrical or plumbing permit. The scope of the work and the permits have to be obtained prior to serving any kind of termination notice. Once you serve that termination notice, the tenant moves out, you must do the work. Now, most landlords aren't going to want to rent the premises back to the same tenant. They want to get a fresh tenant in there. But if you do, you would have the right, if you're subject to statewide rent control, to rent the premises to that same tenant for market value.
Great. Jeff on YouTube is asking, just want to confirm on July 1st, we cannot require more than 1 month security deposit, regardless of the credit score. And that's a great point. People that would have been accepted, you're not going to accept them because you can't get 2 months of a security deposit.
Right. And that would be a wonderful way of screening tenants in addition to getting a credit check through the Apartment Owners Association by saying, look, your credit is bad, but I feel for you. I'll tell you what, give me a 2 month security. Normally I only charge 1, but if you give me a 2 month security, at least I'll feel like I have some protection. Well, any California state legislators who are listening to me or the government, you've just stopped them from gaining entrance into the building. So your policies, which are always bankrupt, are going to make it more difficult. Just like with the $20 an hour for fast food restaurants, what did you do? You put so many people out of work. Your do good intentions never work. Let the economy work by its way, by a free economy. When you don't mix in, everything works fine. But this is what you're going to get. But this is the state that we live in.
All right. And Joseph on YouTube, we have a tenant in the area of Sherman Oaks. So everybody, Sherman Oaks is LA City, and that moved in. We don't know if this is under RSO or not. Let's just assume that it is. So when you write your question, if you just let us know where you're at. Otherwise, we'll just assume that it's regular California and just California state rent control. So we increased the rent. Okay, they had an extra tenant move in, so they increased the rent 10%. And about 3 years later, the extra tenant moved out. Do we need to bring back the rent to the original price?
Okay, based on the way you've written your question, I would guarantee that this is under the rent stabilization ordinance. So under that ordinance, if an additional person moves in, you are entitled to a 10% rent increase. But the ordinance is very clear. If that person moves out, then you've got to give back. You have to reduce the rent by 10%.
And refund, probably refund if they took any rent that was over that amount. They should probably refund
Well,
that.
it depends. Once they found out, then they're at that moment in time, then the rent fee is dropped.
Okay, got it. So once you found out, all right. Just smile. That's great. Tenant joined tenant association and now failed to pay rent and claims harassment. What can we do if he hasn't met the threshold? So
Okay,
that's
so
go for it.
there is this criteria that under the city of Los Angeles and also unincorporated areas of LA County, there's this quote, ability to sue a landlord for harassment and then obtain attorney's fees. But generally, the landlord has to do something. If I'm asking a tenant, hey, pay your damn rent, that's not harassment. That's your God-given right. That's what the contract states. So I wouldn't worry about that. What the writer is talking about, also dealing with the threshold. So in the city of Los Angeles, as I pull up my chart here, for example, for a one-bedroom apartment, you can't serve, this is insanity law. And by the way, this is also in unincorporated areas of LA County. You can't serve a 3-day notice for a one bedroom unless it exceeds $2,006. So if your rent, for example, was $2,000 and he's refusing to pay you and saying harassment, well, first of all, laugh off the harassment charge. You would have to wait until July. At that point, $4,000 would be owed, and then you would be able to serve a 3-day notice. The chart also goes on for an efficiency apartment. That would be $1,777. For a 2-bedroom, it's $2,544. For a 3-bedroom, $3,263. And last but not least, for a 4-bedroom, it's $3,600. By the way, I'm not a genius. I have a cheat sheet in front of me, which is how I'm rattling off those figures. Now, the politicians, again, in the city of Los Angeles and unincorporated areas of LA County, wanted to make it so that it was easier for tenants and more affordable for tenants to give tenants a chance as opposed to being evicted. So let them sit there for another month before you could serve a 3-day notice. The truth of the matter is that all that's doing is stealing a month's rent from the landlord. But more importantly, if the city was really intent on making, quote, affordable rents, you would have to be literally out of your mind. And now I am going to share my screen here again. You'd have to be out of your mind, ladies and gentlemen, if I had a two-bedroom apartment, I would never rent it even close to $2,544 because that means I'd have to wait 2 months for my rent. So from right now, what you're doing is you're forcing landlords for a 2-bedroom unit. I don't care where it is. The minimum standard is $2,444. And by the way, it goes up every year. It's going to go up in September, October 1st of 2024, which is just in a few months. So I'm going to rent that unit out for $2,700. That's got to be the minimum standard. So what did you do, city council and county supervisors for Los Angeles? What you did was you created a situation where you're forcing rents to go up, just the exact opposite of what your intentions are. So I hope you guys are listening and I hope every landlord's listening. If you're in an unincorporated area of LA County or the city of Los Angeles, I don't care what your unit looks like. Everybody else is going to be charging above that. So you can feel comfortable in getting more rent because you don't want to be below the threshold. And now I will stop sharing.
Right.
Okay.
And please vote, people, and look at the platforms of the people you're voting for. Are they for property rights or not? How important are property rights to you? And then just please vote accordingly. Okay. All right. Estrella, I have a single family home in Canyon Country. How much can I increase the rent and how many days in advance should I give the rent increase notice?
And the answer is it's a single family home with only one house on the lot. That means under Costa-Hawkins, you are guaranteed to be able to raise the rent to whatever you like or market value, which is probably it. If you're ever curious, ladies and gentlemen, I've talked about this before, as to what the value of your apartment is or rental value or the rental value of your house, there's a wonderful website. It's free for the first 5 times. I have no affiliation with it, but I do pay for the service. And that website is called Oh, me, I should be a spokesperson. They should be paying me for this, Jeff. But it's called rentometer.com. So that's RENT, the letter O, meter.com. You plug in your address, you plug in what kind of a property it is and how many bedrooms and bathrooms, and it'll give you an instant answer. It's worth subscribing to this service, or the first 5 is free. And you can see, you said it was in Palmdale, this house. Then you can see exactly what it is, and you can raise it to that level. Once again, if you go above 10%, then you've got to serve a 95-day notice. So if you were serving it, I'd serve it now. We're in the middle of June, so it would be 5 days. So let's move on to June. So July, August, September. It would be effective as of October 1st if you're going above 10%.
All right. Court say so is on YouTube here. If an RSO tenant is facing a UD due to non-payment of rent and has met, oh wait, we already, okay. Oh, and has met the rent due threshold amount, are they protected by the CARES Act 3-day pay quit plus 30-day vacate notice?
Okay, so this is another reason why no one, even though the law requires that no one should take a Section 8 tenant. If you want to avoid Section 8 tenants, you have to take their application. You can't even rely upon their credit anymore. You have to rely upon the new law called the ability to pay. But Section 8, and I'm raising this because that's what the question really is talking about, Section 8 will not accept a tenant unless you offer a 1-year lease. So from this point forward, no matter who you're renting to, make sure you only offer month-to-month tenancies, then you're not shouldered with a Section 8 tenant. But if you have a Section 8 tenant, you go to the AOA website, you get their 3-day notice to pay or quit, you serve it on them, and guess what? You've already lost your case. Because under the federal rules, under the CARES Act, if you have a Section 8 tenant, you have to serve a hybrid notice to pay, rent, or quit, which is called a 3-day notice to pay or 30-day notice to quit. So they still only have 3 days to pay, but they got 30 days to quit. And that's for any Section 8 tenant, or, believe it or not, if you have a federally funded loan. If you have a federally funded loan, or you have don't get those federally funded loans, even though I think I have one for the building that I'm sitting in. I guess that's an SBA loan, but I don't have a landlord. So, but I guess if I was evicting one of my tenants from this building here, and it is a federally backed loan, I guess I'd have to serve a 3-day notice to pay or a 30-day notice to quit. However, my son is a tenant in this building, so I'll just take away the keys from his car if he doesn't pay his rent. But in any event, under the CARES Act, if your property is a federally funded loan or your property is Section 8, you have to serve that hybrid notice, which I am proud to tell you is on the AOA website. 3-day notice to pay, 30-day notice to quit. There's also additional forms under the CARES Act that have to go with that, which I also presume is on the AOA website. Make sure it's almost like serving a 10-page notice because the guy didn't pay 1 month's rent, his share of the rent. So yes, it is that additional hybrid notice. And so keep in the back of your mind, if you got a Section 8 tenant or a federally backed loan, I got to do something different if a tenant fails to pay the rent.
Yeah, I really appreciate that question because I think more people need to serve that than they realize because they have that federally backed loan. Okay. Hermosa property change in ownership notice is adequate service to send by snail mail, email, in person. How are they supposed to serve that?
I wouldn't send it by email unless your rental agreement provides for that as a method of serving notices. Otherwise, I would mail it. Maybe you want to mail it with a proof of mailing from the post office. Don't have it where you certified mail return receipt. They'll never sign for it. So if you're going to do it certified mail, just do it without return receipt so that it just gets there and you can prove it got there, or do a proof of mailing. That's sufficient. Or you can just personally deliver it by putting it on their door.
Okay, Giovanni, getting into the nuts and bolts on that notice. Can the address be of an office and management mailing address, or does it need to be the landlord's personal home address?
It can be for either payments of rent or addresses for service of legal process or demand notices. It can be anybody. You got to have a name, you got to have a physical address. So it can be the owner. And I know owners are so reticent about giving out their address. I mean, I know I don't do it for my buildings. They don't have my home address, so I guess you can figure it out pretty quickly. And by the way, I'm serving lunch on Sunday if you want to come over. So that was a joke. But in any event, you can authorize an agent if you want to, with a name and an address, and which is not the owner's address.
All right. I have a mailbox service that receives notice for me. Is the type of arrangement acceptable?
That's not acceptable. Well, we're getting some pushback, even though a mailbox service has a physical address, where you can actually walk in like Mailbox USA and hand it to somebody. That's not considered a proper address. It's got to be a physical address. It's not really a pseudo PO box.
Okay. Char Young on YouTube. Do I have to serve a change in ownership form if I'm helping my 97-year-old father with tenant issues? Rent is still paid to him directly. I only answer repair calls.
I don't have a problem with that as long as the rents are going to be, there's no change, even though, you know, I could have a manager of my building. That doesn't mean that I've changed it. But if you've changed where the location is for the payment, then you've got to do one of those notices.
Great. Teresa, Los Angeles, we have a tenant that is not part of the original contract signed in 2006. He has 9 children and another one is on the way. Can we increase the 10% once the baby is born?
And the answer is, I presume you're talking about the city of Los Angeles under LA rent control. So number one, you can't get the 10% unless you serve that notice within 60 days of when you knew or should have known that the additional person was brought into the unit. With regard to children born into the unit, the first one is free. The second one, you can get that 10%. So get ready for that. Happy birth. And then you can reward the parents with a 10% rent increase, assuming that there was another child that joined the tenancy after its inception.
Okay, Jurlong here on YouTube. Can landlords still charge key deposit, pet deposit, last month rent?
And a refrigerator deposit. You forgot that one, right? And the answer is no. It's only called a security deposit. You can't sneak around and try to get more deposits by calling it something else. I was kind of playing with the idea that if the rent's $2,000 per month, that maybe for the first month you charge a $2,000 for the rent and $2,000 for the security. But maybe I'm going to call it that for the first month that the rent is $4,000 and that from that point forward, it's only $2,000 for the rent. But the first month's rent is $4,000 and that's what it says. So you're basically getting your double security deposit. I'm not so sure on the legal sufficiency of that or whether you'd get anybody to agree to that, but I've been trying to play with that and it might come out if you read the Apartment Owners Association. I'm trying to think of whether that would work or not. But again, you can't call it anything else. It's a security deposit.
Or you could do it like they do it in Germany, where you just strip everything out of the unit and have them add everything.
Yeah, you have to pay for a toilet. You have to pay for a washer. A stove, etc.
No, I'm not saying do that. I'm just saying that other places, they are doing that. So, okay, YouTube, Susan, with regard to mandatory physical address for accepting legal services, what can we do if we absolutely do not want to give out our personal residential address?
Well, that's why I said during the telecast, maybe you have a brother that you don't like and give him his address because you don't like him anyway. It doesn't matter the reticence that you have with regard to giving out your home address. Then you got to a point, then you know what? Go get yourself a management company. There's tons of them that are in the Apartment Owners Association magazine that have been vetted by the association. And you might want to look to the magazine, which is invaluable tool for vendors, and pick one of those. And then they're your management company. And that's who's going to get served the lawsuit.
Yeah. And yeah, okay. So many things that I could talk about. Okay. Polaire on YouTube, how did they determine the CPI to be less coming up, but more prior? So the amount of inflation was greater in the year prior, and that's how that happened.
Exactly.
Okay. The next one here, I raised rent in San Diego on 12/1/2023, 5%. Can I raise rent again before 12/1/2024, and how much?
I think it's only once per year. So that's the way the statute's written. So you're going to have to wait 1 year from when you last raised it. So make sure you do maximum rent increases. Do not feel sorry for these tenants. Just act like it's supposed to be. It's a business organization. That's what you're running. And please try to get your rents as close to market value, which means that anytime you can do a rent increase, do that rent increase. We have clients, it's crazy. They've waited 4 or 5 years to do a rent increase. Then they finally serve a rent increase, and the tenants, they're outraged. How can you raise my rent? Well, it just creates a situation where if the tenants are expecting a rent increase every year, do it. Okay. There can be some examples where you give some incentive for the tenant to do something else. For example, you buy a building and the tenant, there is no rental agreements. You had a bad previous owner. You might, and the tenant's refusing to sign your rental agreement. Then you might say to the tenant, you know what, I will forego a rent increase this year if you sign the rental agreement. So you can use it as some incentive to get something else that you want. But other than that, you want to raise the rents anytime you legally can to the maximum amount as allowed by law.
Yeah, and it's rent control that forces it on people. I mean, it's crazy how it's just works backwards. All right, Rose Gold. Dennis, is there any limitation on requiring first and last month rent if we can only charge 1 month security deposit? We kind of
You
answered
cannot
that.
charge a last month's rent.
Yeah.
You can only charge a security deposit. Any deposits that you take would be considered a security deposit. So if I charge a security deposit of 1 month and a last month's rent, you've just violated the law because you took a 2 month security deposit. Now, a little known rule, which might work in some cases for you guys, and again, making it for those politicians to hear what they've done with this limitation on security deposits, is that you need to, if you have a rental agreement, you are under the law allowed to charge the first month's rent a security deposit, but you're also allowed to charge up to 6 months to 1 year's rent in advance. So I could charge 6 months rent plus the security deposit. So for those tenants that are shaky, you could say, look, pay me 6 months rent in advance. Can you do a 5 months rent in advance or 4 or less? The answer is no. So it's either 1 month, the first month's rent and a security deposit equal to 1 month's rent, or you can take a 6 months to 1 year's rent in advance plus the security deposit. So for those tenants that are shaky and now you can only get a 1 month's rent, that might be another tool that you can use to secure yourself that your rents are going to be paid.
And that's great. Like there's international students that come in and there's no way to verify their credit history. They don't have any yet. Like that's a great way. Just go for the whole year up front and they'll probably be able to do it. So, all right. Sylvia, all this raises apply to rent control. So that's a tough question. Okay, I'll just let you respond to it.
I didn't hear the question, sir.
Oh, yeah. So all the raises that you're talking about apply to rent control?
That is correct. So it's either statewide rent control or a local rent control jurisdiction. For example, Santa Monica, West Hollywood, Culver City, you name the list. But if your property is like a single family home, I don't care where it is, or it's a townhouse. I don't care whether you have that exemption in your rental agreement or not. You can raise the rent to market level. Okay.
Right. So Lilia, unincorporated LA County, a tenant left. Can I raise the rent to market value? You still can, but everybody's got to
remember, vote no against justice.
You got to vote. You got to register to vote if you haven't. You got to vote no on that proposition. You had it listed as Proposition 20. I guess it'll come out in July. What the specific number?
Right. Well, you have it right behind your Proposition 10. So
well, yeah, it was 10, and then it was.
Yeah, we don't know what the number is, but it's justice for renters. You want to vote against it. You want to make sure that you bring all your family members with you. Bring all your friends with you. If you happen to have a Great Dane, dress it up as a human and have it go into the voting polls. Because, as they know, politicians don't require proof of identification, right? So you
Are
can bring
you
a dog in
encouraging
as far
voter
as I'm
fraud here,
concerned.
Dennis?
What's that?
Are you encouraging voter fraud here by dog?
Well, you know what? As a representative of the apartment owner association, I will take that statement back. But call me privately and then I'll tell you.
Okay, all right, Mark. Do you anticipate rental agreements with a term of less than 12 months to become subject to statewide rent control?
Yes, I don't recommend 1 year lease for a multitude of reasons. One is that you can legitimately reject a Section 8, or they'll legitimately reject you because you refuse to do a 1 year lease. Under statewide rent control, you don't need cause to evict for the first year. You do not need cause to evict for the first year, which means that I'm just not getting along with this tenant. He's not doing anything, quote, in violation of the rental agreement. He's just a miserable person to deal with. Here's your 30-day notice, get off my property. Also, as we now know in the city of Los Angeles, if your property wasn't subject to the rent stabilization ordinance, it is now subject to the just cause ordinance, which means you need just cause, even for a single family residence, to ask a tenant to move because you're intending to sell the property. That wouldn't be a reason to evict. However, in the city of Los Angeles, under the just cause ordinance, you don't need a reason for the first 6 months. So that's another reason why you shouldn't give a 1 year lease or a 6 month lease. Just do month to month. You're not going to chase these people for their rent if they move prior to the term of the lease anyway, in most parts. So you might as well do a month to month rental agreement. And then even for the just cause area in the city of Los Angeles, you'd be able to just serve a 30-day notice within the first 6 months.
Okay, Raquel, is an additional 4% to the 8.9% after a certain time? Should we raise the security deposit too? So I
I
think
don't think you can legally raise the security deposit once you've charged it. And I'm not sure what you mean by the 4%. It's statewide rent control is now going to go up to 8.9%. And that would be a 30-day notice plus potentially 5 days for mailing.
I think she's referring to that 4% that was kind of like the makeup for LA RSO after.
Well, if it's statewide, then it's not LA. So 4% would just be a LA rent control ordinance. That's effective as of July 1st if you haven't raised the rent. But if your property is not subject to the rent stabilization ordinance for the city of Los Angeles, then you're probably subject to statewide rent control, and that's 8.9% effective August 1st.
Right. So Raquel, that's statewide for LA and Orange County is the 8.9, but you may be under RSO. Make sure you know which one you're there, or you have that right anyway. Mike, if you have a guest house in Northridge, which is the city of Los Angeles, how do you know which jurisdiction you're under?
Well, very simple. If you've got 2 dwelling units on one lot in the city of Los Angeles, then you're under LA rent control. The only exception would be if both or one of those properties received a certificate of occupancy after October 1st, 1978. So let's pretend this ADU, accessory dwelling unit in the back, was just registered, became legal, or certificate of occupancy was issued in, let's say, the year 2020. Well, now you're not subject to any rent control. So you could do an unlimited rent increase for that unit. And it doesn't need to be registered with the city of LA under their RSO because it was built after October 1st, 1978.
And what's the website where people can type in their address and figure out?
Oh, there's Zemus.com.
Yeah.
I think or is it Zemus.org? Let me check real quick.
Yeah, it's not.
I think it's Zemus.org.
Yeah.
As I look it up here. Oh, it's actually Zemus that's ZIMAS LAcity.org.
Right.
And you can check it out there and figure out whether your property is subject to RSO. But again, if your property is in the city of Los Angeles, if you're not subject to RSO, and I don't care if it's an $85,000 a month Brentwood mansion, you are subject to JCO. So if you want to sell the mansion and you want the tenant to move, that's not a reason. Thank you.
All right, Hoopty Tank. City of LA RSO property. Original lease has 4 renters listed. 2 have left. This is a wonderful math question, right? 2 have left. Remaining renter had a child that is now an adult. Can rent be raised 10% increase since more than the original number of occupants?
Well, I don't think it's more than the original because you said there was a total of 4, 2 left, and now they had a child. So that means there's only 3 there. So it certainly hasn't exceeded the original level of 4. It doesn't matter whether that the names have changed. It only matters how many people are there to get the additional 10% for the city of Los Angeles. So the answer to that is no. Also, the firstborn child into the unit, you can't get the 10%.
All right.
Again, that's the city of Los Angeles.
Right. Okay, so we have an 8-unit building in Richmond, Contra Costa. I must follow Contra Costa rent laws and not the statewide, correct?
If Costa Country, whatever, has their own local rent jurisdiction, then you can't follow it. Then you
Yeah.
have to follow that, not the statewide.
So on the lease agreement, now we had this conversation not too long ago, and so I think this is a good question. People don't know what to do with that box. Do they need to check that they're exempt from AB 1482 if they have a local rent control, or do they not check anything?
Okay, I would check it that it's exempt because what happens if the city of Los Angeles comes to its senses and abolishes rent control? I know that would never happen. But then since the
Or
rental
Contra
agreement,
Costa in this case, right?
okay, right, whatever. So in that situation, what if they abolished it? Now you didn't check the box. So I think it is exempt from statewide rent control because it's not subject to because it is subject to the local jurisdiction. So on that basis, I'd check the box. It doesn't hurt.
All right. Next question. There's a 7-unit that's going to turn into an 8-unit after the addition of an ADU in the city of LA. Current building under rent control. Is a new ADU also under rent control?
And the answer is absolutely it's under rent control. The only way it wouldn't be would be if there was a separation of the unit. In other words, that unit was built in the back. We had a situation once, this is many years ago, where they built an ADU, but what they did, they kind of spruced it up a little bit and they had what they call a breezeway, which attached the main house to the ADU, but because of the breezeway, which is kind of like a little roof that extends between the two where you can walk through it and be out of the rain, since it was attached to it, LA City Rent Control was saying that that is now still part of the first unit because it's attached, and therefore you are subject, both units are subject to RSO. So my advice to the landlord was very easy. I said, go get yourself a saw.
Okay. So I'm sorry, it's Clint Miller here. Would you please repeat the amounts required in arrears for the different sized units? Okay, so he's saying the minimum, the threshold, he's asking
Okay,
for a repeat.
let's go to the threshold again. And as I pulled that up right here, for an efficiency apartment or a single, that is no bedrooms, it's 1777. So I can't serve a 3-day notice unless it's above the threshold. So it would have to be 1778. For a 1-bedroom, 2006. For a 2-bedroom, it's 2544. For a 3-bedroom, 3263. And for a 4-bedroom, 3600. Now, I've got a question for you, Jeff. Is the city saying that therefore, if it's a 5-bedroom, I don't have to have a threshold? What's your opinion on that?
I bet you they're just going to go with the 4, the largest
And
one.
the answer to the question is for anything over 4, you add in a 15% increase. So whatever
Really? Okay.
3,600 is plus 15%. And then up the way. So if you had an 8-unit building, I mean, go get your calculator out, but you have to, and that has to be above the threshold. So that's actually what the law is. Nobody knows that, but.
Yeah. Okay. Now we all know. Okay.
Oh, by the way, you know, a trick we all know, and you might want to put this in your notices. We all know that for the city of, this is how they get you. The city of Los Angeles and unincorporated areas of LA County, you have to have the amount of bedrooms. So that's in your form, Jeff. But
Yeah.
I don't know if you know this, for LA, unincorporated of LA County, you have to have the fair market value in your notice. So you might want to just, I'm not sure, you probably do. I don't know, I haven't looked at your notices, but you want to have the fair market value. So you could just put in what they all are so that the tenant knows it's a 2-bedroom, but have the chart in there. And if you don't have that for unincorporated areas of LA County, you will lose your eviction case.
Yeah, I kind of think we do, but I have to go back and look.
Okay.
There's been so many forms that have had to be that we had to
Updated.
update,
It's crazy. It's, by the way, I spend my I do that webinar, that Zoom meeting on Saturday. So what do I do on Sundays? Sundays I make sure that all my forms are in compliance. So
Yeah.
it's a full-time 7-day-a-week job that I'm dealing with here, even with my 27 attorneys, by the way.
Right. Okay.
Let's do a
Okay. So
couple more, Jeff. Okay,
what's that?
let's do a couple more.
All right. All right. So, Clint, we're going to go on to other, I know you have multiple questions there. We're just going to go on to the next one. Okay. Sonia, single family SFR in city of LA with an ADU rented. Are we still exempt from rent control?
Okay, I presume the house was built prior to 1979, October 1st, 1978, prior to that. So on that basis, the house now is under LA rent control. You're limited to the 4% rent increase. The ADU, I'm assuming, was built within the last 15 years, so you're not subject to any rent control, and therefore you can raise the rent unlimitedly for that. Now, what happens if your ADU the house was built, let's pretend, in the year 1935. Okay, now you put in 1980, you built the ADU. So all of a sudden, the day you built the ADU, you are not subject. Your front house is now subject to rent control because there's 2 units on one lot. The ADU, prior to statewide rent control, there was no rent control. You could do whatever you like with that. But now with the advent of statewide rent control, and since the ADU is older than 15 years, you now have to do an 8.9% come August 1st for the ADU.
Okay, here we go. Sylvina, Section 8 tenant, paid her deposit with a third-party organization. Who does she return the deposit to? To that nonprofit or to the renter?
You return it to the renter.
Oh boy, nice, huh?
You have no contractual relationship with that caregiver, that charity organization. They didn't sign any rental agreement with you. And on the rental agreement, it states that the tenant paid that security deposit. So unless there's some agreement, you can't give it back to the organization. You got to give it to the tenant. That's a really good question, by the way. In fact, I'm going to use that one in the next questions and answers for the Apartment Owners Association magazine that I write.
Right. I mean, if there's any article to read, I mean, besides the president's message, you got to read.
Actually, I read the president's message first. I don't know who writes that. Who writes that, Jeff?
I don't know.
And then I go to my own.
Yeah. So the legal Q&A, honestly, like just reading that every month, at the very least, read that because it'll just kind of keep you sharp and help you remember things. Okay, David, let's see. We'll do YIP here since there's not very many left. Can we charge a fixed amount for the utilities, water and trash per head count on top of the rent on the lease agreement in a fourplex under 1 water meter?
Well, if you spell it out in your rental agreement upon the tenant coming in, then you can charge whatever you want because it's vacancy decontrol. So you can't say that you have to pay for your utilities. You'd have to give them some sort of a formula as to how you're deriving that. But once that formula is placed in the rental agreement, you're okay. I'm not a big fan of that, especially if there's only 1 meter. It just creates problems for tenants who say, well, this guy has 4 people in the unit. I'm single, and why am I paying my contributive share to this? You know what? If you can charge whatever you want when the tenant moves in, then just build it into the rent so that there's no argument. So if you think his utility share is going to be a maximum of $300 per month, build it into the rent. So if it's $2,700, make it $3,000. I think it's an easier way to go, but you certainly have the right, since that's what the question was, to do it upon anybody coming into your unit.
Okay, Celia, Los Angeles rent control. Do notices have to be provided to tenants in Spanish?
Okay, if you negotiate your rental agreement in Spanish, then every notice has to be done in Spanish. Every 3-day notice, every rent increase, otherwise it's not proper. I recommend that regardless of what language you speak, that you only negotiate in English and let the tenant get a translator. Only use English rental agreements, only negotiate, not a word comes out of your mouth that's in Spanish, because otherwise we can lose a case on that basis. We had an outrageous decision which we're appealing because the judge was just damn wrong, but it went to the issue that there was some discussion in the Spanish language when the premises were entered into, so therefore the notices should have been in Spanish.
Right. All right. Well, hey, thank you so much, Dennis. Do we take one more, or what do you think?
One more.
Okay, last one. Okay, Carlos, what if a tenant paid 2-month security rent before security deposit? I think he means before the law passed.
Good question. If you got a security deposit, you keep the security deposit. You don't have to give any money back. This is only for security deposits that are taken at the initiation of tenancy, which was initiated as of July 1st, 2024. Don't forget, there is an exception. If you have 2 properties with a total of 4 units, you can get a double month security. Don't forget the issue that if you put something in an LLC, that's a different owner. So on that basis, you might be able to get around the law.
And so you did say keep it. And what you mean is you don't have to refund 1 month, and you still have to give the whole thing when they do move out, except minus whatever, right?
Right. You get to hold on to the security deposit until the tenant vacates.
There we go. There we
For
go.
clarification.
All right, everybody. And again, I said it kind of at the beginning, and I want to say it again. It is getting harder and harder to identify criminal court records. LA County and I believe Sacramento and a couple others now, they've removed the date of birth. So the instant criminal searches are, by law, they just can't show, they can't verify the identity, then they can't show that information on an instant criminal report. And so even if you did everything through a different company, at the very least get the live investigator report through us. And what's great about it is when you think criminal, you think it's going to be every single kind of record available, but criminal means criminal and it doesn't mean civil. So there are civil court records that very much matter, like domestic violence and financial crimes, and even just seeing how litigious they are. So just keep that in mind as you go to rent out your place. And, it should be kind of second stage if you approve them based on all the financial, then take a look at that. And anyway, we really want you to succeed, and we're going to continue to give you the information that you need, and hopefully we'll continue this journey together, and we're very thankful for you. Thank you, Dennis, for just answering questions, taking the time with everybody for this.
Appreciate it, Jeff, and appreciate your organization.
All right. Take care, everyone.